Today, we are going to talk about the promotion of research and development through the incorporation of new mechanisms in the intellectual property laws of the Philippines. Intellectual property is all around us, from trademarks that distinguish goods from one another, copyright covering books, and to inventions protected by patents. We will focus on patents. A patent is akin to a deal between the state and the inventor. The inventor discloses the technical know-how of the invention to the public, and in exchange, the state protects the rights of the patentee by giving him the exclusive right to restrain any unauthorized person from making, using, selling, or importing that product. This term of protection lasts for 20 years. Thereafter, the design becomes part of public domain and everyone is free to improve or use the same. The state can also employ push and pull mechanisms, provided that these do not contravene the TRIPS agreement. Protecting and promoting intellectual property is of paramount importance, especially in times of crisis or epidemics. For example, expired patents can be used to produce essential technologies. It will also provide an avenue for pharmaceutical companies to recoup their investments in developing drugs and medicines. Intellectual property protection also plays a role in the economy. In 2018, the countries of origin of the top patent filers account for roughly 42% of total trade of the Philippines. This discussion will focus on three major points. The first, on international exhaustion, then on licensing, and finally, on the incorporation of push and pull mechanisms. In a nutshell, international exhaustion allows for parallel importation because once an invention has been sold anywhere in the world, the economic rights for that particular item is deemed exhausted, and such item can be exported to another country. Adopting an international exhaustion regime has its advantages and disadvantages. It provides more options to consumers and drives down the price of the products. It will also facilitate the growth of the industry by promoting competition. However, competition is a double-edged sword, as it will hurt domestic enterprises which are unable to compete with foreign goods. Thus, I propose that an international exhaustion regime be adopted for certain industries, such as those dealing with national defense and essential agricultural technologies for a period of 10 years. A balanced combination of this regime and mechanisms such as tax breaks and subsidies for infant industries will allow these local industries to weather out foreign competition. I also propose that there is a need to redefine consent. In this fashion, the rights under Section 71A of the Intellectual Property Code should be taken separately, and that the sale of a product is not tantamount to consent to the importation of the same in another country. Still, this must be interpreted hand in hand with competition law, and there must be a legitimate business interest of the patentee that must be affected in employing a strategy of price discrimination. The next point will be on voluntary and compulsory licensing. With regard to voluntary licensing, I propose that to hasten the negotiation process, the patentee must include a statement of willingness to license his product as part of the application process. On another note, a compulsory license permits a third party to utilize the patented technology without the consent of the patent holder under certain circumstances. It is my opinion that the grounds for granting a compulsory license be limited to where the patented invention belongs to an industry imbued with public interest. Further, a requirement should be added that there must be a genuine necessity for the utilization of the patented invention or that such use is essential to maintain the life and security of the people. Finally, we will talk about the incorporation of other mechanisms in the Intellectual Property Code. The Intellectual Property Office can be given the mandate to regularly prepare patent landscape reports for vital industries. These reports will provide a snapshot of the situation of a specific technology and provide stakeholders with an idea as to the areas that need more attention. In addition, priority review vouchers can be given to certain inventions which are identified as beneficial to the public, considering that the average pendency time from filing to grant is 48 months and that the term of patent protection is 20 years from the time of filing. An accelerated proceeding will definitely provide a first mover advantage to the patentee. In conclusion, intellectual property plays a role in the stimulation of research and development. Thus, there is a need to strengthen incentives for innovation and incorporate innovative measures in the intellectual property code. Thank you.